Welcome to the Maison Law Podcast.
Hey everyone, welcome into an all-new episode of the Maison Law Podcast with attorney Rozanna Pondeva Gasparian, a senior immigration attorney over at Maison Law Immigration. I'm your host, Mike Leon. You know, with more than a decade of focused exclusively on immigration law, Rozanna has regularly guided families through complex residency and adjustment cases, especially when there's eligibility questions that are not always, as straightforward. Today's episode, we're going to be talking about an adjustment of status and whether someone can apply for a green card without having to leave the United States. You know, Rozanna, this is an apropos topic because immigration is in the news front and center. A lot of people are confused about a lot of different things. So let's start with this. The adjustment I just mentioned, what does the adjustment of status actually mean with respect to immigration law?
Absolutely. So first of all, thanks for having us back, Mike. So adjustment of status, in essence, is a process by which someone who is a non-citizen, so basically someone who's undocumented and who is already physically present, so you have to be actually here within the United States, that person has the opportunity to apply to change their status from being undocumented, or maybe they have some sort of other non-immigrant status, to becoming a lawful permanent resident, which is basically, in essence, you're getting an immigrant status. And so that is the opportunity or the route that you take in order to go from no status or non-immigrant status to legal permanent resident.
And how does that kind of change? Like what determines whether someone is allowed to apply for the green card while they're staying here instead of going through that consular, process abroad?
Absolutely. So there's a number of factors. So adjustment of status and consular processing, just to kind of give a background, are in essence the same thing, right? It's a person, like I said, who has no legal status or who has immigrant status and who's trying to get lawful permanent residency. They're going through and what people in layman's terms call like the green card process, right? But one version, which is the adjustment of status process, takes place here within the United States. You're applying for that green card or that lawful permanent residency with what we call USCIS, or United States Citizenship and Immigration Services, here in the United States. Consular processing is basically doing the same process, but you're doing it partially, or the majority of it is done abroad. It's generally in your home country, back where the person is coming from at a U.S. consulate, and they're the ones who get to determine whether or not you get the status. Now, to kind of give the difference in terms of which of the two a person is eligible for, I normally like to break it down to our clients as follows, right? So there's 4 criteria that a person has to meet in order to be eligible to do adjustment of status here in the United States. So the first and foremost, you have to be physically present in the United States. If you're outside of this country, you don't qualify for adjustment of status. The second thing you have to do is you have to have what we call proper lawful admission into the country, or parole. Meaning at one point or another, the person entered the country either with some sort of a visa or some sort of parole was granted to them to allow them to enter the country. There's also a set of very minor exceptions that allow individuals who came undocumented to the country to also apply for that green card. But generally speaking, you have to have been somebody who entered this country through some sort of lawful means, right? Like you were admitted, you were inspected by Customs and Border Patrol, or they paroled you into this country. So for the third one, the third criteria is you have to have an immigrant visa that's available to you. And generally speaking, the only individuals who have immigrant visas, Mike, are individuals who are immediate relatives. Either you have a parent, a spouse, or a child who is a U.S. citizen, sometimes can be a green card holder. But those are the people, if you have a familiar relationship to one of those 3 categories, you have generally an immediate visa available to you. And then the last category, or the last eligibility criteria in order to apply for adjustment of status, is you have to have no bars. So there are many different things that we call bars in the immigration world, whether it's, time in terms of like having permanent bars, 3-year bars, 10-year bars are the ones people generally hear. If you have some sort of criminal issues, you have to be an individual who doesn't generally have any problems or any bars that prevent you from getting adjustment of status. So if you can meet those 4 criteria, you would be eligible to apply for adjustment of status or to get your green card here in the United States and go through the process here rather than have to travel abroad.
Yeah. Well, it's a great explainer, Rosie. And then, like I said, it's very apropos given, what's happening right now around the world of immigration. I wanted to go back to something you just said there about without inspection, because I think that may have been lost a little bit for folks there. So can we go back and let me ask you, for the individuals who did enter without inspection, how does that actually change compared to someone who's entered here with a visa?
Absolutely. So I think normally when we do these, when we speak to clients, that's generally the determining factor 9 out of 10 times is if they can apply for adjustments, if they came in illegally or they came unlawfully, right, is what the term they use at this point in time. So I'm going to kind of give an explanation of what entering or being admitted and inspected are and what being paroled into the country are. So generally speaking, admission means it's a lawful entry into the United States after you have presented yourself at a port of entry, right? Like at some port border, Customs and Border Protection, an officer has inspected you. They've inspected your admission documents, meaning you have some sort of a visa that gives you the legal right to enter this country, right? You either have a tourist visa, a student visa. I mean, there's many different employment visas, but you've been granted some sort of a document that gives you the legal right to enter this country. So you present yourself at the border, you present that document, you're inspected at that point in time by a Customs and Border Patrol agent, and then you're admitted into this country. That's option one. The other option is you are able to apply for adjustment if you've been what we call paroled into this country. So parole, in essence, is you've been granted permission to physically enter this country, although you don't have some sort of a travel document that allows you to enter. So you may not have been given any type of a visa. But you may have some sort of an emergency exigent circumstances where you approach the border and Customs and Border Patrol will allow you to enter the country physically for, humanitarian purposes. There's a number of different areas of parole that you can be given. And so if you're allowed to enter the country through parole or through the proper admission route, then you are able to go ahead and do that process of adjusting your status here in the United States. Now, on the flip side of that, a lot of individuals enter the country undocumented, meaning at one point or another, they got themselves across the border without presenting themselves at a port of entry, without being inspected by Customs and Border Patrol. For lack of a better way of saying it, somebody ran over the border or whatever the circumstances may be. They got themselves here in the United States without being inspected and admitted. And so those individuals are individuals that we call entry without inspection. A lot of times you'll hear the acronym EWI. That's what that stands for, entry without inspection. And so if you enter this country, if you're physically present here, but you enter this country without being inspected, you don't qualify to do the adjustment of status process here in the United States. You can, in essence, start the process here, but at one point or another, you do have to return to your home country to attend an interview at the U.S. consulate there for them to determine whether or not you can get a green card. Now, like I said, and very, very briefly, there is an exception to that rule. So there are individuals who came to the United States without being inspected or admitted. Like we said, EWI, entry without inspection. But there are a few categories that the Immigration and Nationality Act allow for certain individuals that fall in certain categories that it's almost like, in essence, like an exception. That exception gives you the opportunity to still apply for your lawful permanent residency here in the United States. So I'll give you just a few basic examples, and this is not, the whole list, but for example, there's individuals who we call something called 245I, which, we see a lot nowadays. So individuals who had a family member petition for them, start the green card process from them back. There's a specific date. It's April 30th of 2001. So if you had a family member who had petitioned for you prior to that April 30th, 2001 date, you, in essence, kind of get this exception, which allows you now to go ahead and apply for your green card here without having to depart the country. Individuals who are granted, military parole in place. So a lot of time, parents or spouses of individuals who are in some branch of the armed forces, right? Those individuals who may have entered the country unlawfully, meaning they came in without being inspected or admitted, if they're granted parole in place here in the United States, then they can go through the green card process here as well. So there are a few exceptions to the general rule, Mike, but in essence, kind of the determining factor is that admission and parole versus coming in undocumented.
Well, let me piggyback just real quick on that one, because you mentioned marriages within there, and that's obviously common in California. You could tell me if I'm wrong, but what has to be true again for a spouse to qualify for that adjustment of status while they're inside the U.S.?
Absolutely. So, um, that's obviously marriage cases are a very large portion of the adjustment cases that take place here in the United States. In essence, there's a few factors that they're looking at, right? First and foremost, the main key factor that immigration is looking at when a spouse is applying for their spouse to get lawful permanent residency is we call it, is your marriage what we call a bona fide marriage, right? And bona fide marriage, really, to break it down, is your marriage a real legitimate marriage, right? So bona fide, the term bona fide is a Latin term that stands for good faith. So did you enter your marriage in good faith, right? Did you really marry this person because you truly wanted to build a relationship and a life and a marriage with them? Or did you just marry them for green card purposes? And if you did marry them for green card purposes, then that's obviously a significant issue and that can be considered fraud. So that's the first thing they're looking at. It's really, is your marriage what we call a bona fide one?
Right.
The second one is, again, you have to have entered the country lawfully, right? Admitted, inspected, paroled into the country, or you fit into one of these exceptions. The third thing, like we talked about, is you're physically present here in the United States in going through this process. And like I mentioned earlier, you have no bars, nothing that prevents you from being eligible for a green card. So if you can meet those criteria, that criteria as the spouse of a United States citizen, you are eligible to apply to go through the adjustment status process here. But really, marriage, you're looking at the bona fides. That's the key aspect there.
Right. This isn't a TLC show, right, Rosie? Anyway, so listen, let me ask you though, because this is another topic that's apropos that's playing out in the news, and you hear this a lot, and it's about overstays, right? That's very common, I'm sure, with given your practice. When someone has stayed beyond their visa expiration, how does that impact eligibility? Because from my understanding, it has changed given the new administration.
Absolutely. So I can kind of give you a background. So normally speaking, when individuals come to the United States and they're admitted and they're inspected, or they're given, if you come on a visa, for example, let's take the most basic example. Most people come on a tourist visa, what we call like a B2 visa. Sometimes they come on a B1 visa. That's the common one. So when you enter the country and you're inspected by the Customs and Border Patrol agent, they give you a duration of time, and I'll kind of explain this later on in more detail, but they give you a duration of time in which you can remain in the United States, right? Normally, they say the majority of the time they give you about 6 months or so on a tourist visa. So you enter the country and you've been given 6 months to remain here. And before that 6 months, for example, expires, you have to depart, right? And so the moment you overstay, you literally stay past that expiration date, you are now considered to have overstayed your visa, and you are now considered to be, in essence, what we call an unlawful status. You have no legal status anymore. Your visa status is no longer valid. Well, so what happens in relation to the adjustment process, and why is it important? So up until recently, which is kind of what you're, talking about, Mike, is up until now, we didn't have any issues. If you were an immediate relative, right? If you were the spouse or the parent of a U.S. citizen, for example, even if you had overstayed your visa, could have been a month, could have been 6 months, could have been 5 years, right? Normally speaking, when you went to apply for that lawful permanent residency, when you went to apply for a green card, that unlawful time that you had basically overstayed, regardless of what that duration was, it was almost as it was like forgiven for you, right? So they forgive you because you're an immediate relative of a U.S. citizen. They would forgive you that time that you had been here undocumented or out of status. That is still kind of the process right now. But unfortunately, what we've seen recently with this administration is a lot of times people are showing up to those interviews. They're showing up to the adjustment interview after they've submitted their applications, an interview has been scheduled. They show up, and what they're facing is they're getting detained. They're getting detained at these interviews, and the basis for that detention, ICE is alleging, is, oh, you've overstayed your visa, which is something we had never seen before, quite frankly. And now they're charging individuals as being deportable, and they're saying you're basically removable for having overstayed this visa. And so it's basically causing significant additional issues in the process of applying, which was something we hadn't seen this before. It was something that didn't exist, regardless if, like, again, if you were an immediate relative, there's a specific INA section, Immigration Nationality Act section, that basically states that individuals of immediate relatives can have that unlawful presence forgiven. And so that has significantly changed.
Yeah. The E stands for enforcement in the agency's acronym. And, it's apropos given everything that's happening, Rosie, because a lot of people don't understand that immigration law is very separate from U.S. criminal law and things like that. And you mentioned something within your answer about documentation and what they look at with your application. Can you kind of explain for the audience what type of documentation does immigration closely review in these adjustment cases? Has it changed given the new administration? And where have you seen kind of problems where people run into problems given their applications?
Absolutely. So I think regardless, a lot of times the documentation is dependent, obviously, on the type of case, right, that is being submitted. The case of a spouse versus a child applying for their parent, those are different types of documentation and evidence that are required. But nonetheless, there are some general, things that everyone needs to have, and some primary documents that immigration is always looking at in terms of evidence. So let's talk about, for example, a marriage-based case, right? In a marriage-based case, what is immigration specifically looking at? Well, they're looking at evidence of the relationship, right? We want to make sure that that relationship, like as I mentioned earlier, is a bona fide one, right? It wasn't something that was started yesterday. You're going to have documentation to support the actual relationship. I don't know, I give examples to our clients. Do you have text messages from all the years you've been dating, talking back and forth? I don't know, is it photographs, whatever it may be. If you are now, or you should be now married, have you started to commingle and to join your lives together? And in doing that, how have you done that documentarily, right? So I don't know, you join bank accounts together, you have rental agreements together. How are you able to show on paper that your relationship is real and legitimate? So that's the first key factor, and that's the first type of evidence that immigration is looking at. The second thing they're looking at significantly, and this is across the border, again, regardless if it's a marriage case or not, the second thing that they're looking at is the applicant's history, immigration history, right? We're looking at the number of entries somebody has into the country, the number of exits, how long have they remained in the United States during each trip that they've taken here. Do they potentially trigger, or have they triggered any bars? We have like a 3-year, a 10-year bar that then would prevent you from getting any legal status. So that's what they're looking at definitely as well. The third thing they're looking at is a criminal background, criminal history. Have you been arrested or have you been convicted of any crimes that make you ineligible to get a lawful permanent residency, right? And we call that an inadmissibility factor, but these are all things that immigration is looking at very much in detail to make sure that a person qualifies for adjustment. Outside of those, obviously, things that I see normally that individuals kind of have hiccups with, or, things that they start to face problems with, is a lot of times these different things that I just spoke about, Mike, they're not documented well, right? So what we see a lot of times is people submitted, one rent agreement and 5 photographs, and that is not going to be sufficient enough to provide or to prove bona fides of a relationship. A lot of times somebody was arrested or convicted of something. They failed to provide court documents, right? You have to be able to provide the court certified dockets, is what we call it, from the court explaining to immigration what transpired in your case. So a lot of times it's just a failure to provide the proper document or the right amount of documentation to support your case. I think that's where people start to see a lot of issues. And a lot of times they'll get what we call a request for additional evidence, where basically immigration comes back after you submitted your application and they say, hey, we still need XYZ, or this is not sufficient enough, and we want to see additional evidence of all of this.
Yeah, it's a lot of information to process. And Rosie, I can't thank you enough for the time, the insights, and breaking this all down for the audience. I appreciate it as always.
Absolutely. Thank you so much, Mike.
And that's it for today's episode of the Maison Law Podcast. Look, if you have questions right now about your status in this country or any other questions related to immigration law, contact Rosie and the team over at Maison Law Immigration by going to masoниmmigration.com right now. And do me one other favor before you go. Hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.